Well, certainly we have two elements here. One is the constitutional right, the freedom to worship. And this is a constitutional right not only in the U.S. Constitution protecting freedom of religion, the Oregon Constitution guarantees the right of freedom of worship. And Ray Hackey with the Pacific Justice Institute came in initially asserting this right and challenging the closure orders from the governor, shutting down churches or then limiting them much more than grocery stores and department stores and the like. So Ray Hackey and the Pacific Justice Institute were working with me. I was talking to them on behalf of Common Sense for Oregon. I've known Ray for a couple of years, and we were supporting this. Then we chose to find some interveners who both were asserting their religious rights, but also businesses that had to lay off employees, people who had to cut back tremendously on their business activities because they were shut down, loss of business revenue, all of the damages economically and the damages in terms of religious rights. We packaged that together with our interveners and came into this case. So Common Sense for Oregon, which is the organization I work with, was involved along with Pacific Justice Institute. The original theory was let's talk about protection of religious freedom. But we built on that, and as we moved forward, we saw that the statutory scheme here did not empower the governor to continue doing what she was doing. We saw that there were three elements to the statutes. Well, I'll say two elements to the statutes and one constitutional element. We pointed out to the court that every state is different. We've got 50 states, it's a federal system. We had looked at a number of other states and found that they all have different provisions about the powers of the governor. But here in Oregon, first of all, we amended the Constitution in 2012.
Right.
We added a whole new article to the Constitution, referred to the voters by the legislature as a constitutional revision, which meant it had to have a two-thirds vote of the House and the Senate. It passed the Senate 30-0. It passed the House 57-3. It was HJR 7 in the 2011 session, put on the ballot for November 2012 as Measure 77 and passed by a strong margin by the voters. Now, that article had to do with catastrophic disasters, very serious situations, including war, terrorism, earthquakes, volcanoes, and public health emergencies. Specific category. It empowered the governor to declare a catastrophic disaster and gave her tremendous powers to control what was going on in the economy and society, which would include closures of businesses, limitations on churches, but only for 30 days. And within those 30 days, the governor had to go to the legislature if they were in session. If they weren't in session, the governor had to convene the legislature. Not an option, had to do it. And then the legislature would have to decide by a 3/5 vote of the House and a 3/5 vote of the Senate to allow the governor to continue to have any extraordinary powers. Otherwise, the powers were done on the 30th day. So separate from whether or not those powers could have included restrictions on churches, which is another issue on its own, the powers themselves expired. So the problem with that was, as we researched it, saw this is really the tool the governor should have used if she thinks this is such a terrible pandemic. It's got a permissive clause. It says the governor may declare a catastrophic disaster. So while we pointed out that the constitutional provision and all its powers, we did still note there's a 30-day time limit on that for those extraordinary powers. So we dropped back to public health emergency. Oregon is one of the few states, in fact, we haven't found another state yet that has written a comprehensive law about public health emergencies. And this was done from 2003 to 2007. It defines a public health emergency that includes this pandemic that by definition was included in a public health emergency, and it granted the governor extraordinary powers. One clause of that statute gives the governor the power to close businesses, enterprises. You could argue that includes churches, maybe. But the public health emergency statute has an expiration clause. It says the governor may declare a public health emergency, which is effective up to 14 days. She may extend it by 14 days, and that's it. So there's 28 days under the public health emergency law. Now, what the governor is relying on is a 1949 statute that was written, when you read it, and you follow the amendments, it was mainly amended up to 1983. They had one thing they passed in 2008 that allowed her to waive the 1 week waiting period for unemployment compensation. But otherwise, the last substantive change was 1983. That law never mentions a public health emergency. And it does not empower the closure of anything. It allows the governor to intervene, to mass the resources of government, state, and local, to intervene in a community, yes, to exclude people from areas of danger. It allows the governor to be engaged in cleanup and providing temporary housing. It was designed clearly for forest fires, for floods, and for storms. And again, it never mentions a public health emergency. Now, the governor's folks say, well, the public health emergency law has a reference to allowing the general emergency powers to be used during a public health emergency. Okay, but that's still a 28-day time limit. Then they say, oh, but the public health emergency law has a clause that says that the governor, in declaring an emergency, rely on the public health emergency laws. Yes, but that clause with the 28-day limitation has to do with the power which is only inside the public health emergency statutes. So when you want to use that little time bomb, it's got a 28-day limitation on it. And when you try to shove it over into the general emergency statute, the 28 days goes with it. So the governor's power to close, which is really what we're arguing here, which the lesser values have to do with the other restrictions within that as to when and where and how you can use your premises. All of that comes out of the public health emergency statute. The circuit court judge heard our arguments and agreed, and he issued an order saying that after 28 days, the governor had declared this to be a public health emergency on March 8th, the very first day. And the 28 days later, that declaration had no further effect. Now, she might have tried to say after that general emergency, which she cannot go back to the closure powers, which she has tried to use. In fact, she has used to close down colleges, universities, schools, and yes, effectively churches, as well as all other kinds of businesses in this state. So where we are now, the judge ruled properly in our opinion. We weren't surprised that the state had already warned last week that they would seek immediate emergency review by the Supreme Court. They took it up, and the Supreme Court allowed us to respond to their motion for an emergency stay, but promptly issued an emergency stay. What is significant there, though, is they also said that we need to submit our briefs on these issues by Friday, May 22, or earlier if possible. Normally, under appellate procedure, we would have to have responded to this petition to the Supreme Court, which is a mandamus case, by June 1st. So they have accelerated the time frame under the rules, and it shows me at least that they have a sensitivity to the time factors involved here.
Does it matter that I think it was late on Thursday or Thursday afternoon that the governor released a new executive order replacing many of the executive orders? Did you say it starts over again? And that was done without fanfare, by the way.
No, the governor cannot start over again. He declared a public health emergency relating to the coronavirus pandemic on March the 8th. Having declared that as a public health emergency, our position is you don't have to get around this by letting the 28 days expire and start over again. The statutory limitation has to have some meaning. Now, what we do think happened politically is the state even told the court during our 3-hour hearing on Thursday that, oh, the governor is about to have a press conference and she'll be taking further action and we should see what the governor does. And I really think that we've already forced the governor to retrench somewhat in the eyes of the world for fear that her lack of authority will be exposed.
This governor has not been very public as far as press conferences and explaining her rationale. As a former legislator, former candidate for governor, former head of the Republican Party in Oregon, do you have any observations on that?
Yes. If the governor is going to be exercising leadership in regard to this issue, she needs to be out in the community. She needs to be meeting with the media. She needs to be explaining. We have said all along in this litigation, the governor's not prevented from encouraging, supporting, advising, suggestion, suggesting, asking people to do what she thinks is the right thing about social distancing, wearing masks in various places to reduce the potential spread of the coronavirus. She can do that. Instead, she has relied on this assertion of absolute power from behind the curtain, so to speak, where she occasionally walks out in front of the curtain, speaks to the media, declares what she's doing, and then goes back behind the curtain. So I question that. I also question why the governor has turned our counties into a mother may I situation, that childhood game, mother may I, where they have to ask permission to engage in their reopening under her standards. This is a reversal of the powers of county government. I've tried to respond to the questions about what do you do if it's really still bad in Multnomah County and Marion County. Those county commissioners have their own inherent powers to declare a local emergency and do something that's needed to be done in that community, although they will also have to be responsible to their own voters about what they do, and they'll be sensitive to that. So there's opportunities locally for things to be done, and it is an insult to our democratic system of government in Oregon that those counties are now relegated to playing Mother May I. Then you might ask, why have they not objected? Very simple. The governor now has in her purse tens of millions of dollars of federal emergency dollars that she gets to distribute to the counties. And if you're a naughty county that questions the governor's authority, the naughty county is going to get a lesser share of those resources. That's my political read on that. So the counties are going through this very respectful process. They're not challenging the power of the governor to tell them what to do. And I think there's a political reality. It's tied to, gee, we want some access to those federal dollars, and they're all in her purse.
What haven't I asked you that I should have?
Well, how sensitive has this governor been to our basic freedoms as Oregonians? And I think that she has been insensitive. We have a constitutional provision, not only of freedom of expression, which is affected by how we can gather together and do things, but also a freedom of assembly, public assembly, to assert our rights. And she's tried to restrict those, to limit those, to forbid them. And then we have freedom of worship, the capability of people to come together and worship God as they wish. Those are three essential constitutional powers of the people in the Oregon Constitution. And I have seen no sensitivity in regard to those constitutional rights.